Hi, everybody. My name is Becky Witt. I am not Janice Bowie, Ph.D., unfortunately. I don't know exactly where she is. She is one of our board members who is going to be the moderator. And instead, you have me. I'm a staff attorney at Community Law Center, and I will be moderating this panel. So I'll just, since I don't have bios, I'm going to let you briefly introduce yourselves and your presentations, and I'll try to keep time. So Jackie Hand is our first presenter. Welcome.
Hi, I'm Jackie Hand. I teach property, environmental law, American Indian law, and from time to time land use at University of Detroit Mercy Law School. We're right down on the river. And essentially what I'm going to be talking about today is using Detroit as a sort of case study to look at some of the problems. One, my experience is, at least for the moment, we're the flavor of the moment. And everybody wants to hear about what's happening in Detroit, so I hope you all are part of that trend. But also, I think because it's sort of paradigmatic, it helps us sort of look at the broader issue of how urban agriculture is hopefully reshaping our cities. Essentially, part of why Detroit is a good thing to talk about is in Detroit, size matters. Everything is large scale. The quantity of vacant land that we have is essentially huge. It's roughly a 20 square miles. Now that figure's a little bit squidgy because when they initially made it, they didn't take into account that some of that was parks. But it's still a very large proportion of the roughly 140 square miles of the city. And let me get, okay, this is part of what's going on. I don't do PowerPoints with lots of words, but I always think pictures are fun. So this is mostly going to be pictures. This is one of the bleaker areas. Okay, I was just saying, if we're, the only issue is if it gets dark enough where I can't see my notes.
I understand.
Actually, we'll move on to the next one, which is more interesting.
Yes.
There. Yeah. That gives you an idea of the quantity of essentially vacant land in the city. The bad news is that we have that much vacant land. The good news is it provides lots of opportunities and lots of decision points as to what in fact is going to happen. Essentially, and I think this is useful to get a picture, Detroit, this gives an idea of the numbers of vacant parcels. They're scattered all over. One of the issues is obviously land consolidation, like with any other kind of development. But this map, I think, is the one that tends to stick in people's mind. Detroit is a very big city, territory-wise. At our height, we had roughly 2 million people. Very few, I've been driving around Baltimore in the last 24 hours. I'm really impressed with the row houses. Detroit had a very strong tradition of, even if they were small, single-family homes on their own lots. I can only think of one district that has a bunch of apartment buildings going back to the turn of the last century. It was never a very dense city, and the other statistic that I think is sort of interesting is even now, with the shrinkage, it is still denser than Phoenix and Houston. So it's a whole different pattern of initial development. For that reason, what to do with this vacant land has a very large part to the revitalization of the city. The Detroit bankruptcy is way beyond what I'm here to talk about today, but just a short news bulletin, knock on wood, it's all going to go through and in a very positive way. And part of the positivity, I'm not sure that's a word, that's coming into play is the sort of activity that urban ag has been and the real focus that urban agriculture, and while there are there's lots of folks gardening in their backyards, lots of community gardens, but The real concern, and what I'm really talking about today, is urban ag as economic activity, as businesses, as a creature for urban revitalization. Now, when I said Detroit is big, I also mean in terms of the sorts of things that are happening. One of the things that you may have run across is something called Hans Farms. This guy is a hedge fund guy who lives in the city, white guy, who essentially is trying to assemble, usually asking the city give it to him, 3,000 acres on the east side of Detroit to run large-scale farming. It has been pulled back. As of now, he has 20 acres that has just this spring been planted in an urban forest. The interesting thing is it's hugely controversial in the city. A number of community organizers on both sides, good people who are community spirited. Some folks are, if he cleans off the tires and cleans off the weeds, we know he's a land speculator, but it's worth it. The other side raises the sort of obvious concerns. One thing I just want to make is a note that I think is very interesting in Detroit. I'm a watcher and academic. I'm not a doer. I hate weeding. But I do go to a reasonable number of community meetings. And the one characteristic that I have found very heartwarming is that in general, there is no sense of racial division in terms of this. Everybody's in favor of urban ag. They may have some disagreements as to how, what's going to happen. Even the opposition to Hans is framed in terms of the city council shouldn't be handing over that much land to an individual. And I think that's, in one sense, maybe the most optimistic note, because a lot of our urban farmers, and I'm just going to flip through some, just a sort of an interesting historical point, urban farming has a long history in Detroit. In the 1890s, when there was one of the many recessions that hit, the mayor Pingree basically opened up all the vacant city land to then recent immigrants to grow food so people wouldn't go hungry, and they were called Pingree's potato patches. So I just think that's sort of, I'm sort of an intellectual jackdaw. I pick out little interesting things that appeal to me. And then just here is some of mostly community gardens. This, I think it's a very infelicitous name, just as it's hard. This is a 4-acre garden that the city has given land to in a very large urban park to Malakakini, who has been doing this 10 or 15 years. So there is a strong community garden. This garden is sort of interesting because it's a combination of a business, but very much a community enterprise. And these two young, actually I think they're still in school at University of Michigan, have just sort of bought a little land and squatted on more and gotten a garden and a community center going. Okay, here's just a couple more pictures. Okay, this is Hans. Okay, one of the issues then is the question of scale. And because there's so much land, there are the advocates for whether it's Hans or someone like him to do a very large scale sort of activity. I think that is a concern, and one of the things, before I move into the sort of relation between state regulations and the city, is one of the things I think those of us that are concerned about how this develops over the next few years is what is the best scale. Now this I sort of like is because I just visited this farm for the first time. It's 4 acres, 1 city block in what was an old elementary school. This is a catfish facility. Basically, and if you notice, it's all handmade, it's not a commercial. Catfish down below, when their externalities then just get moved up to the planning development on the next 2 layers. Low key, a commercial activity, but big enough. I mean, one of my concerns, and we'll talk a little bit in terms of nuisance and anti-nuisance legislation, is how small a plot should you allow, for example, chickens? I mean, I think livestock is one of the big concerns. This is a big enough area then I don't have concerns. The chicken facility is right in the middle, so neighbors are not going to have some concerns about what operates with this. See, that's pretty much some more. I'll leave it on those before we go ahead. Now, despite all this activity, and as I said, Malik has been involved for a long time, essentially anything other than your backyard garden was illegal in Detroit until this January. Basically, the city did not do any zoning or other regulation because of the Michigan right to farm law, that essentially at the state level took away all powers for the city to regulate or structure how urban ag would do, so it was simply easier not to deal with it. And that's the real focus of what I want to talk about today. Is I think one of the problems, again, as we try to develop paradigms for this system, is urban ag isn't rural agriculture. And at least in Michigan, the entire structure was built around not only rural, but essentially big ag kinds of concerns. And this created a real problem. Now, sort of a backdrop is the reason state decision making, and particularly as the Michigan right to farm law has been a problem, is that the state is completely in control. And I don't know how many folks here are lawyers, but there is always tension in terms of whether the feds can preempt state activity because of the intricacies of our Constitution. At the state level, the state is the sovereign. And as my understanding is that in any state, the state legally, constitutionally, could abolish counties, could abolish cities. The smaller units are simply that, smaller units of the state government. So what I'm talking about for the rest of this is not, is it legal or allowed? The answer is yes. The question is it wise? One of the first things that I learned when I was practicing is just because you can do it doesn't mean you should do it. So what we're talking about here is the state's exercise of power that is completely allowed, but does this make sense? Now, this saga all starts with the passage of right to farm law in Michigan. Now, when it originally was developed, and these started about 20 years ago, and they're now in some form in every state, was concern about movement of particularly suburbanization. Remember, we're all spreading out along highways that engulf traditional farmers. All of a sudden, you move into your new subdivision and spring comes and the farmer spreads manure. All of a sudden, those cows don't look as appealing as they did when you're moving to the country. So essentially, right to farm laws were designed to protect existing farms from folks who came to the nuisance, which in nuisance law is always a factor. What the right to farm law did was designed to say this is the determinative factor. If the farmer was there first and was acting, and some of the statutes say reasonable, Michigan says generally accepted agricultural practices. So if you're acting like a normal farmer and you were there first and you were doing it essentially when the people moved in knew what you were doing, fine. And that sort of goes along for a while. But then, in effect, the steps in because big ag people were complaining this doesn't give us enough protection. So the first thing that happens is the state ag department, rather than what are generally accepted practices being done on a case-by-case basis in a sort of parallel to nuisance, which is it unreasonable, they issue regulations. And if you're doing what they say is generally accepted, you're protected from any sort of nuisance lawsuit. Now, this caused some problems in rural areas because people who were on traditional family farms didn't particularly like being next to a hog factory, and were still challenging this. And they were going to their local governments and saying, you got to stop this. So then the next step was the legislature says local governments cannot do anything that is inconsistent with either the right to farm law or the GRAMPs, which are these sort of things called. So now hands are completely tied. Combined with the Michigan court system, this is designed primarily with respect to commercial. But the Michigan courts, could I answer at the end?
I'm missing
Sure.
something. I guess what I don't understand is how was Big Ag not adequately protected, and then how were hog farmers also not under the right to farm thing?
Well, they were, and what happens is they didn't want to be challenged, and people were saying under the GAMPs you were allowed to operate, again, not a hog farm, a hog factory or a feedlot, things that created a lot of burdens on neighboring issues. If I could come to that at the end, because I've gotten my 5-minute signal. So essentially, what you had is, and if you were even selling a dozen eggs a year, you were labeled as commercial, and the local government could have no input on how much setback you had, what your buildings had to look like, or anything like that, in any way different from these sort of statewide GAMPs. Now, as people began to look at the possibilities of urban agriculture, there began to be a lot of pressure on the state. And earlier this year, the Ag Department, interestingly now it's the Ag and Rural Development Department, which I think gives us sort of a good idea as to part of what the problem is, issues of regulation, and it essentially says, with respect to livestock, any city over 1 million people can regulate. Now that leaves an awful lot of people out, but was enough that the city of Detroit went ahead and did develop a zoning ordinance. Now the problem is, so that pushes some of the decision-making back to the city. That doesn't deal with a number of the things that, when I talk to various gardeners in the city, is the biggest concerns are pesticides. People are very concerned, and I think it's very clear that pesticide use is preempted under state law. So the city cannot limit what? Now, most of the folks that I talk to, including the commercial people, are organic, but that also makes them vulnerable if there's no pesticide. The other big concern is GMOs. Now, most of the products that are GMO tend to be row crops, bigger things, not lettuce and carrots, but the movement is in that direction. I think there's a real concern, and the city can't do anything about it. And if you get into different animals, if you look at the sort of, there's examples of the complaint structure, for various animals, it's everything from ducks to llamas to alpacas come into play. Somewhat more limitation. So, and I know there are a number of folks, and I tend to think as well, that it's really nice to think of, having chickens and this sort of thing, but depending upon the size of the property, it's really difficult to, as my example is, I have kitty cats, and their litter boxes are often not wonderful, but it's within my house. It's not impacting anybody else. If I'm raising chickens, and even if you're doing it exactly right, it may be fine, but if you aren't as on top of things, can be a problem. So my concern is that there be developed, that as we envision where we want to go, and like I said, the problem is more intense in Detroit. Can I have like 2 minutes? Because of the size and the importance for the economy, that we start thinking about a way to bring in local concerns, to let neighbors have an input. I'm not sure we can have it all, but I think if we look at things that way, we may have a good chance. And I just want to show you a couple more of the farms. This one I like. This young lady has a quite small duck farm called Late in Detroit. And this is what we hope happening. Again, notice the veggies, but then the troubled buildings directly behind. Thank you. By the way, if I skipped over anything too fast, that anybody would like me to make the connectors more clear,
Sorry.
we'll have to talk about it, later at lunch or whenever we get an opportunity.
Great, thank you. Thank you, Ms. Hand.
This is advance, and then this later part. Press it
Okay,
down.
great. So our next presenter is Neil Thapar. Thapar. Apologize for
No
that.
problem.
And he is an attorney, staff attorney at Sustainable Economies Law Center in Oakland, California. And he is going to discuss an effort at statewide legislation to preempt restrictions on growing food currently prescribed in tenant leases, HOA covenants, and local zoning ordinances. Thank you.
Thank you.
So this is just for you to advance.
So that's
Okay,
going
great.
forward. Perfect. Does it leave it? Hi, everyone. My name is Neil Thapar, and I'm really glad to be here to talk about some of the work that we do at the Sustainable Economies Law Center. Today I want to talk about our advocacy work to pass legislation which we think is the first of its kind, called the Neighborhood Food Act, which would legalize certain urban agricultural activities throughout cities in California. As of today, the bill sits on the governor's desk, and we're waiting for him to sign it. So maybe with all the inspiration from this conference today, we'll transfer over and he'll actually sign the bill, which would be great. Okay, so a little background about SELC. We're a nonprofit organization. We provide legal services for individuals and groups to promote community empowerment and grassroots economic development. We do this through research, education, advice, and advocacy. So research, a lot of the research that we do leads us to learn about different ways that laws apply to the kinds of enterprises and businesses that we want to see in the new economy. So questions like, how do public utilities law relate to renewable energy enterprises in communities? Or what employment law questions come up in cooperatively owned businesses? Or even a recent question is a CSA subscription a security? So I don't know the answer to that question, by the way, so if anybody does, it'd be great. So that we often find surprising answers, and this ends up being something that we want to share with the public. So what we've done is developed a bunch of e-resource libraries. So they're basically online compilations of information that we try to make as accessible to the public. And we have them in a variety of our program areas, including cooperatives, community currencies, and the most relevant to today is about urban agriculture, which I'll talk about more in a second. We also provide legal advice to a small number of organizational clients and to many more people in the public through a legal cafe, which is what we call the Resilient Communities Legal Cafe, which is a walk-in advice and referral clinic. And so we also host some educational workshops, some of them more formal trainings, and then also several informal discussions with community groups. And then lastly, what I'm here to talk about today is our advocacy work. And as a legal organization, we weigh in on policy decisions at the state and local level to help create the legal framework for the kinds of communities and kinds of enterprises that we want to see, but that currently operate in a legal gray area or completely outside the law. So I mostly work in our food program, and the mission of our food program is it here? No, it's not here. I'll just tell you what our mission is. To develop local food systems that are based on community-oriented businesses and sustainability. And so we try to complement the work that urban ag organizations do by providing the legal advice and the policy recommendations that support that, the local food systems. So just to tell you a little bit about how those 4 strategies play out in the food program, the first, like I mentioned, is urbanaglaw.org, which I encourage you all to visit. It's our online legal resource library for people trying to start or people who are already doing urban agricultural projects, which we curate and create content for, but we also rely on a really wonderful group of volunteers to develop content for the site, some of whom are here. And so they're lawyers, they're law students, they're non-legal people who are planners or anybody else who has a specific expertise in an issue related to urban agriculture. One thing that I want to do that I want to make a plug for here is that I think this resource can be really valuable for law professors who want to develop research projects for their students and then look for a place to publish this information. And so if anybody here is interested in that, feel free to talk to me after the conference or some point during the conference. Advice, I already mentioned the Resilient Communities Legal Cafe. It's where we meet a lot of clients, and a lot of them are doing food and ag work. One thing to note here is we also find out about a lot of legal issues that arise in the community through this cafe because we have clients come in with a lot of the same issues. And so that encourages and influences some of our policy work as well. Legal Eats is part of our educational programming. It's a guide for starting a food business, so it covers employment law, entity formation, health and safety regulations. It's focused on the Bay Area, which is where we're located. We also do a workshop as well. And then our advocacy work. So previously, in 2012, we passed legislation called the California Homemade Food Act, which was a cottage food law in California. I think there's something like 2,000 cottage food operations now in California, so we're really happy about that. And we also, like I said, weigh in on policy recommendations. So right now we're developing a food policy agenda that's going to focus on localization, community and worker empowerment, and sustainability. So that should come out sometime early next year. So here's what I hope is a simple question. And I think that most people here would probably answer yes. And the United Nations says yes too. But actually, in California, and I suspect in other states as well, access to food by growing it is not actually something that you have a right to do if your landlord says that you can't if you're renting, if your HOA says that you can't if you live in an HOA, and if by chance you want to sell that food, if your city's zoning doesn't allow it. By the way, is everybody familiar with what HOAs are? No. So essentially, this is probably because I'm from California and you're not from California. HOAs are non-governmental bodies that regulate a whole variety of things, but one is land use in a particular common interest development where, so if you think of condominiums, that's a really easy example of what a common interest development is. And so the HOA is the governing agency for that.
Subdivisions in Maryland.
For subdivisions.
Governed by homeowners association.
Yeah.
No, if you would have said homeowners association,
Oh,
then what
these acronyms, sorry. Well, they're really, yeah, so they're really common in California and a lot of other states. And not just condos, but entire subdivisions, almost large developments. So we're talking about renters and people who live in HOAs. How many people are we actually talking about that may not have a right to grow their own food? So there's 38 million people in California, 36 million who actually live in housing. So of that 36 million, almost 46% are renters, which is one of the highest proportions in the country. Of the other 19 or so million, 4.5 live in common interest developments. So if you put that together, that's actually 60% of the people who live in housing in California may may be subject to the whims of their landlord or their HOA and may not have an access to growing their own food. So we thought that needed to be changed. And so what we came up with is the Neighborhood Food Act. So as drafted, the bill recognizes a lot of benefits of urban agriculture as state policy. So it recognizes the importance of food security as a way of growing your own food. It recognizes the link between healthy access or access to healthy food and diet-related illnesses. And it establishes a state policy to promote access to fresh produce and to encourage people to grow their own food. So the substantive provisions of the law expressly protect the right of tenants to grow their own food for personal use or for sale. And it also protects people who live in homeowners associations from growing their own food for personal use, even if there's a HOA agreement that says something to the contrary. And then finally, there's a section that amended the state land use law to restrict cities from completely prohibiting the growing and sale of produce within city limits, even if zoning ordinances didn't allow it. So the idea behind this section, I think, which gets to Jackie's point, is to try to create or to promote urban agriculture as not just a way for people to access food, but also as a community economic development tool. But at the same time, increasing access for food locally. So under the law, just to be clear, all zones in a city would be considered zoned for agriculture. So this didn't require cities to go back and update their zoning codes. It just added an overlay that said all zones are zoned for agriculture, and which included sales. And so another feature was that we defined these terms, community garden, personal agriculture, and entrepreneurial agriculture. And if you're interested in the definitions, you can look at the text of the bill. There's a link at the end of the slides. So this is what we wanted out of the law. And we knew we were going to meet some resistance, and we weren't disappointed. We faced a lot of opposition from local government groups, from landlord groups, and from HOA groups, as you might imagine. So the local government groups, they were really concerned about local control over land use. And so this is kind of the flip side of what Jackie was talking about, where we were actually hoping to preempt some local control here to promote access to food. So there was by right language in the bill, which essentially means that someone could start growing food and selling it, and they wouldn't have to go through the planning process. Another word I think that's commonly used is either a permitted use or a primary use. So someone could theoretically start growing crops and selling it, and of course, assuming that they were complying with all other applicable law, they wouldn't have to get a variance or a use permit or go through any planning process. And so this possibility really jarred the local government organizations. And so at committee hearings, we started hearing stories that, you know, if local control was taken away, that people would be able to start driving tractors through cities and sort of bulldoze neighborhoods. And whether or not that was accurate, that got legislators' attention.
Sorry, that was for private property?
Yeah. Yeah. So another concern that they had was health and safety requirements and traceability. And this was something that we explained was already covered by existing law. And that I think I would probably, if I had to do this again, would make specific reference to the zones, the health and safety code sections of the code in the bill to really clarify that this law wasn't exempting urban agriculture from all these other laws that were already on the books and that existed. But that was what we heard from the local government associations. And then they were also worried about traceability in case of, for food safety concerns. And then we had the landlord groups and the HOA groups who were not happy about this bill. And the landlord groups were primarily worried about property damage, liability, and then the freedom really of contract, which they felt was being infringed by this bill. And then added to that, the HOA groups felt like their principle of self-governance, which is really a defining feature to a lot of the common interest developments, was being threatened by this bill. Another funny story that came up was that people were concerned that if folks were going to be able to grow food in their front yards, and for some reason corn was the scapegoat crop, if people were going to be able to grow corn in their front yards, that maybe this would lead to an increase in property crimes because people would be able to hide behind the corn before they committed their crime. Which is funny, but at the same time, it triggers in the legislator's mind, public safety, and as soon as that gets triggered, it's sort of difficult to then get past that in their perspective. We found outlaw corn, maybe, yeah. So then there were some more challenges that were not related to opposition, but were more related to just communications and logistics during the process. And the first and the most frustrating for me was just how little understanding there was in the legislature about what urban agriculture is. Legislators either thought this was kind of a silly bill because their perception of urban ag was just growing a few herb plants in your backyard. And on the other side, people were really worried about, the second coming of the Dust Bowl, really. They thought that this was going to be just industrial ag in cities, and that's what we had zoning for, was to prevent that. So there was a real severe need to educate legislators about what urban ag is and how it's a tool for economic development, for food access, for social justice. Another challenge for us was being a small organization and not being in Sacramento, was that we didn't really have a continuous presence. And so we didn't keep a pulse on sort of the daily happenings as well as we could have if we were there. And I think this is my plug for urban ag having a full-time lobbyist at the state level. And then the last was sort of difficulty with the author's office. One, because of their understaffed, them being understaffed, and the other because they had other priority bills that they were working on, and so it was hard to keep them very responsive to us. And one thing that's kind of important throughout the legislative process is making quick decisions at times, especially if you're negotiating with the opposition. And so it was sort of hard to keep track of the staffers, which made it difficult to make good decisions. So at the end, the Neighborhood Food Act was narrowed because of the legislative process. These lobby groups are quite powerful. And so we lost the zoning section and any reference to entrepreneurial agriculture. But it's still a step forward, I think. It's a building block for future legislation next year or the year after. And the policy language remain, which I think is really important because in the future, when we're proposing new legislation, we can look back and say, this is a priority that the state identified as a state policy, and this new legislation is going to fulfill that goal. So really quickly, just a few lessons learned from this process is that framing the issue is really important. Avoiding any discussions about corn leading to an increase in property crime really helps tailor the discussion and keeps legislators focused on the issue and keeps speculation and skepticism out, which is important if you're going to have only 5 minutes to present your bill. You want legislators to ask pointed questions. Securing active statewide coalition, this is pretty straightforward. One thing is that we only engage the local officials after they register their opposition. I actually think this was a mistake. I think we could have worked with them earlier in the process to alleviate their concerns or at least negotiate with them. And then we would have faced less opposition during the process. And a bill that faces less visible opposition has a better chance of securing support. And then this one was surprising. A lot of conservative legislators, which I thought would not be super excited about this, actually expressed support, even if they didn't end up voting for the bill. I think urban agriculture as a pathway to to self-sufficiency and local resilience is something that crosses party lines, so that was something that was interesting. Being present in the State House, of course, would be helpful, and then finding an author who really understands the issue and who's going to seek out co-authorships, who's going to advocate passionately for the bill, is really helpful, especially if you're not located in Sacramento or in your state capital. So what's next? We're going to try again. We think that this is a really important piece of legislation, and that the local, promoting local food systems through urban agriculture has the opportunity to sort of change the way our communities operate. And so I think that, so we're gearing up for Neighborhood Food Act 2.0. And I think anybody else who's in another state should take a crack at it as well. If we had neighborhood food acts in every state, I think we could really realize some of the benefits of urban agriculture, not just as a food access solution, but also as community economic development. Thank you. And then here's some resources and contact information.
Thank you, Neil. Thapar. So our final set of presenters are Ashley Newhall and Paul Goeringer. And both Ms. Newhall and Mr. Goeringer are attorneys with the University of Maryland's Department of Agriculture and Resource Economics. And they're going to provide the state's perspective of translating laws and regulations of rural agriculture into cities, and we'll ask the question, is there a right to farm in the city? And one of the interesting things about Mr. Goeringer is that he's still trying to figure out what made him go to law school in Oklahoma. So maybe by the end of the presentation, you'll be able to help him answer that question, as well as the question of, is there a right to farm in the city? Thanks, Ashley.
Thank you. Good morning, everyone. All right, I will start with sort of the briefing of what our right to farm was, which I'm sure Jackie did a really good job introducing you if you didn't already know. And then I'll hand it over to Paul, and he'll kind of apply that to the urban ag law. And this is our website. If you want to take a look and know, we have publications that go up all the time and blog posts, and it's a good resource. So what are right to farm laws? I like to start with Spur Industries versus Del Webb. This was a case decided in 1972 out in Arizona. Spur Industries is a livestock feedlot company, and Del Webb was a home builder. So back in 1962, these enterprises looked like this. As you can see, they were nowhere near each other just yet. But give it a few years, and as you might have guessed, here they are right next to each other. And with that comes some issues. So rural neighborhoods are moving in to an area that was primarily agriculture. Again, you're dealing with the effects of that: flies, manure, smell, dust. So what happened was Del Webb brought suit for an injunction against Spur, asking the court to either halt Spur's operation or force them to move out. So ultimately the court did grant the injunction. However, because this was considered a public nuisance, not a private nuisance, the court made Webb indemnify Spur for his losses. So the fact that Spur was now moving, Webb had to pay all of those costs. So the court reasoned that where the coming to a nuisance doctrine, which Jackie addressed earlier, usually bars relief, there was a public interest at play, and Webb's choice to come to the nuisance could not prevent the public from being protected from the nuisance. So today, all 50 states have enacted some sort of form of a coming to a nuisance doctrine, and we now call those the right to farm laws. Generally speaking, most of these laws require that the agriculture land use either predate, either by time or simply by zoning. And they generally provide a bar against actions brought against them as a result of conditions created by their operations when urban or other types of operations move in. So whether that's a community or something entirely different. Usually, well, in all cases, the agriculture operation has to meet state requirements, and each statute is a little bit different. So taking a closer look, Maryland's right to farm statute says that the agriculture operation must be in existence for more than 1 year, at least a year. And then it also must comply with federal, state, and local health, zoning, environmental permits and regulations. So basically, and like most states have this, they cannot be acting negligently or unlawfully. So GAMP's like out in Michigan, same type of situation here. So the theme right now with these regulations are basically either the expansion of already rural areas, so you have family-owned chicken operations or family-owned, small garden out back. Well, a lot of the issue now is that larger operations are moving in, whether that's commercial or just expansion in general. So a case decided earlier this year out in Idaho, McVickers versus Christensen, what happened here was there were two landowners in a primarily rural setting. One landowner decided to build an indoor horsing arena. Well, his neighbor, McVickers, again, asked for an injunction because it was now causing noise, dust, and other things to actually harm his property, so decreasing his value in his property. The Supreme Court of Idaho held that Idaho's right to farm law did not apply here. Defendants could not use the right to farm law to protect themselves. Well, this was because, again, Idaho's right to farm law provides for a 1 year minimum in existence before the other person bringing the suit, and that the provisions must also include some sort of change condition moving into the area. So it had to be a situation where the agriculture operation was already in there and then someone else is moving in. Well, here, the neighbor was already in existence before the horse arena, and there was actually no change in condition. So again, something that is being tried, the right to farm laws are being tried to be used and not actually being effective. Recently, actually, this isn't current litigation, but an issue that's arisen in Delaware is a proposition by two different large commercial poultry operations that want to build large poultry barns in an area that are currently more family-owned poultry barns. So these are significantly bigger. I believe there's something around 12 to 16 poultry barns, so significantly bigger than already in the area. So a lot of the neighbors are already getting nervous about this. There's going to be, again, increased noise, dust, odor, a little bit of everything, as you can imagine. So Delaware's right to farm law is very broad. It has the same type of situation as Maryland and Idaho in existence 1 year or more and comply with the applicable state federal laws, again, not unlawful and not negligent. So again, the law in Delaware does not provide for any sort of change condition issue. So you might have a right to farm, but does that include the right to actually expand your operation? We don't know. So until this actually either goes to litigation or something starts to happen, we're not going to know exactly how Delaware is going to take that. But we do know that this is coming up in a lot of different states. And even though the right to farm law protections are there are definitely new and novel situations that are going to challenge these state laws. So now I'm going to hand it over to Paul, and he's going to talk more about this for y'all. Thank you.
Okay. So I get the fun part of talking about do right to farm laws apply in the city. Oh, this advances? Okay. So do these apply in the city? So do they apply to urban agriculture? And I may not know why I went to law school. I also do not know if the answer is clear on this either. As we've talked about, Detroit's had their own problems in California. It's not a clear answer on how these laws were written. As I like to say, not one state adopted one and everyone decided we have to follow this law. Some of them decided to adopt one law and then put in every other thing they liked in every other state's law. So we have an amalgamy of laws that make no sense at times. And it's going to depend a lot on how each one of these laws is written. A review of these laws does show that some do a better job of protecting urban ag than they are with others. And we're going to talk about, oh, I need to get before we get started on that, we have to think about one thing. So I have, if anybody knows what this television show is, it was my brilliant idea to put this in here. Exactly. I mean, criminals could hide on Mr. Douglas's balcony while he was growing corn there in California, I guess. But these laws were designed to protect farms against urbanization. They weren't designed to protect urban ag against their neighbors. So the idea at the time when they were developed was we had ever-expanding cities. We had ag land we didn't want to use. We wanted to protect them in some way, like Ashley was talking about in the case of the dairy in Arizona. We had these laws, these farms we wanted to protect, so we developed these laws to protect against urbanization. There were, in most cases, codifications of the coming to the nuisance defense. In urban ag, it's not a coming to the nuisance problem. The urban area already existed. In some cases, the nuisance is coming to the urban setting, so they're not exactly maybe the best vessels to protect urban agriculture. And like kind of hinted at, we never really contemplated the idea that when these laws were developed that there would be food movements in Detroit. There would be food movements here in Baltimore City to where people would want to develop urban agriculture. This was, not an idea at the time that we were thinking about. So let's give some specific examples. And Jackie kind of already hit upon the one in Detroit. So I'll kind of skip over this, and I was hoping she would. But we're going to talk about the one she was talking about, the site selection of new and expanding livestock facilities. So this was revised earlier in the year. Gave local communities of certain size more control. But there was a huge uproar with urban ag communities. Am I underestimating this? Because I have a Google News alert.
Mostly in the
Suburban fringe.
where people, but they're extremely indignant. That, in fact, there's an entire organization set up to protect chickens in suburbs, basically.
Okay. Well, somebody should protect them. But as all this uproar happened, there were a lot of commentators, and one of the best news articles I found on this was out of Al Jazeera, of all places, covering this, Al Jazeera America. They had to point out the law was never designed to protect urban farms. It was designed to protect these farms on the fringe that had urban encroaching on them. And at the same time, it was designed to protect a commercial farm. So if you had backyard chickens, you had bees, and you weren't selling them, it's maybe not the type of commercial operation we were envisioning when these laws were developed. So the idea here is, do we need to reconsider what a farm is? Do we need to rethink what commercial is? That if you're utilizing food on your own property, if you have backyard chickens because you want to utilize those chickens yourself, is that some sort of commercial operation? Some other examples of what they may do is this list of states, and I'm not going to read them all off. They do have abilities to where local zoning ordinances may be superseded in some cases. It kind of depends on how the law is written as how it will apply. And they may not always, and they may sometimes also require that commercial operation. So again, it may be a rethinking of that. We're going to skip over the statute of repose just because of time. So we have these idea of what I like to call the new right to farm law, the right to farm law on steroids. It's not a right to farm law per se, it's a right to farm constitutional amendment. So if anybody followed what happened in Missouri last month, this was a big deal, and I say it narrowly passed. It narrowly passed by, I think, 0.02 of a percentage point. So it was a very contentious fight in Missouri. And the language in that reads that the right of Missouri citizens to engage in agriculture and ranching practices shall not be infringed. So these, as much as I dislike these type of laws, may actually do a better job of protecting urban agriculture because it doesn't oh, I skipped too fast. And now I've messed up. Oh, there's a mouse. Okay. So the jury's still out on these, and the main reason I say that is we don't know what type of litigation is going to come out of these. For everyone that's a lawyer or a law student in the room, you know if you have a constitutional right, it can be reasonably infringed upon. So what is a reasonable infringement on your right to farm? I have no idea, but I'm sure there'll be a lot of court cases that will decide what that reasonable infringement is. So the idea of these laws being designed to protect a lot more farmers may actually end up hurting them because there's a lot more litigation that goes on. That's something we don't know about at this point. But a lot of these amendments don't distinguish between commercial and non-commercial ag, so they may actually offer more protections for folks in urban areas that want to do farming than the traditional right to farm laws. So do we need to change right to farm laws to include urban agriculture? Well, we could change them to include urban to make it more clear, but there's issues with that. Do we want to utilize the law that was designed to protect against urbanization as a way to protect urban farms? Is there a better way? Do we want to do what California did, or are there different ways to utilize this? Should this be a city-by-city decision? Are there certain cities that are going to want to be more friendly to urban ag, or is it something we want to do on the statewide basis to where everyone has this right? So what are my conclusions out of all this? So the right to farm laws were originally designed to protect more farms from increasing pressures from urbanization, as we've already talked about. So they may potentially offer some protections to urban agriculture. It's not exactly clear if they are in all cases. Right to farm constitutional amendments are probably going to offer more protections because they're pretty limited in the amount of words that were used, but are they going to provide for more additional costs to attorneys because everyone loves to pay attorneys more money in the end to solve problems? And should we just consider rewriting and developing certain laws that establish better protections for urban agriculture? And that's it.
Thank you, Paul. Thank you. So, we've heard from 4 different presenters. Jackie, I want to thank you, and Neil, Ashley, and Paul. And we've heard a variety of different perspectives. And we have a good bit of time now to have conversation, to think through some of the issues, a variety of perspectives on how rural laws may or may not apply to urban agriculture, what's kind of coming down the pike, ways in which different cities and states have addressed these issues, and still a number. I guess the sort of take-home message is that there's still, it's unclear, and the way forward is unclear. So I'd like to now open up the conversation and to engage you in questions and your thoughts and perspectives on these issues. So we have, we'll start with you there in the back. Would you make sure that everybody in the room can hear your question?
I sure can.
Okay.
I'm Amy Laricon. I'm a staff attorney with the Public Interest Law Center of Philadelphia. I run a project called the Garden Justice Legal Initiative. I guess the question, the big question I have coming out of all of this is for anyone who wants to answer from the panel, should urban agriculture be putting aside what we already have existing as regulatory regimes, should it be regulated at the state level or the local level, or what's the best balance?
Jackie?
I mean, part of the concern is somewhat result-oriented. I'm concerned about the state level when it prohibits particularly a struggling city from dealing with things. On the other hand, I want lots of preemption when it's a result that I want. I mean, I think that's embarrassing.
That's the question.
I mean, my concern is it's so nifty that we all get excited about it, and we don't think about the other folks that make up the city and who came to the city partially because they want an urban environment. I mean, one of the issues that I see, and I talked to a few people in Detroit, particularly with the whole migration north from the folks who actually have the farm expertise, are black folks that came to Detroit to get away from doing stoop labor in the heat. So I think the devil's in the details. I mean, one of the things I'm playing with, and the problem is it's expensive, is whether the city level is too broad, that if you have a mechanism that we talk about for community development, ideally neighbors who are troubled, and there are all sorts of things. I mean, again, you're not going to have any urban ag unless you've got these. But depending upon how they're set up, if they're, I gather they have like channels that they go, and if it happens to be going right across your patio where you want to sit out and barbecue, it seems to me that ideally we would work through some sort of local arbitration panel where we can get neighbors on board without having to go through litigation. I understand, and I've been trying to check it out, but anybody's here from Minnesota, I would love to hear. I understand that at least the Minneapolis zoning ordinance requires you to go around and talk to your neighbors, explain what you're doing, and try to do the sort of homework ahead of time. That strikes me as an excellent idea. Now the devil's in the details. Some of those things that sound really nifty when you put them on the ground turned out not to work so well.
So, just one comment. Jackie, would you mind joining us? We have a chair down front. So we're going to bring the panelists down so that they can be here and engage. You want to make a comment?
I do on this particular issue. I have, I think, something to share. I'm Mary Kay Siggety. I'm a county council member in Howard County.
Got one for you.
And so Jackie's comments about bees brought home the fact that last year, Kathy, or the year before, the years run together, we had a movement from our local beekeepers asking for zoning regulations that would allow beekeeping in people's backyards. And it was a long process. It was, as Jackie was saying, what we did was talk to neighbors. We described what could happen. We talked to beekeepers. We put into our zoning regulations actually things that people had to do, which was to make sure the flyway did not go over your neighbor's patio, right? And to ensure that it was screened from your neighbors and made placement recommendations, so that our hope was, as we go here, that you could do that activity and be respectful of the neighbors. And we had a lot of community conversation about it, but ultimately it passed.
Thank you so much for sharing that example. Did any of the panelists also want to weigh in on this question, or would you like to move on to other questions?
I have
Go
a
ahead.
question.
Okay.
I wanted to thank the panelists for bringing up the possibility of taking action at the state level too, because what do you do if a city just says no to something that should be a yes? Neil, who have you found have been your best supporters, I guess, in some of your successful statewide efforts? I imagine they had some big backers. You guys had some groups who were behind you guys.
Yeah, so with the California Homemade Food Act, that was a much more widely supported bill, much less controversial bill, you can imagine. And most of the people are interested in starting small businesses. A lot of the urban ag folks were behind it. There's an organization called Slow Food. There's a California chapter. They're a big partner in both California Homemade Food Act and with the Neighborhood Food Act. There's a few organizations that do youth training through urban agriculture that were partners with us on this bill, particularly in Southern California. But I think one of the challenges is to kind of branch out and see who else can be partners that are maybe not just natural allies. One idea was put forward to reach out to unions to have them join the effort, and a lot of the unions in California have wellness initiatives. A lot of companies have wellness initiatives, and so to see if maybe they could be partners to promote urban agriculture. Just to answer Amy Laura's question, I think it's a combination of both. I think I really think of the state level legislation as being sort of guidelines that then local cities and counties can tailor to their individual needs, both cultural needs and their geographic and their sort of physical limitations and specifics. So one thing that we tried to do was not prescribe too many requirements in the legislation and try to leave it open-ended, which can have the unintended consequence of local counties that are not supportive of going the opposite direction, but it also didn't limit and didn't prescribe a sort of one-size-fits-all solution.
So we have a question here, and then I'll come over to this side of the room. And so I'm recognizing the hands, and I'll do the best I can and ask for the rest of you to help me. Okay, go right ahead.
So, the regulation that just happened in San Francisco, zoning urban ag that I was reading about last week, that seemed to be like preceded by statewide, is that correct? Like,
Yeah.
I'm not sure of the details, but like, do you know a little bit more about that?
Yeah, I can tell you a little bit about it. So there's
Could you repeat her question a little bit so that
Sure.
everybody can?
So the question is about a new state law that passed in California last year that the way it worked was it was legislation that was passed at the state level, and then was it sort of an opt-in for local counties to adopt the regulations. And what the law did was provide a tax incentive for landowners who own vacant land in cities to put that land to agricultural uses for at least 5 years, in which case they would get their property assessed at the agricultural value instead of the market value. And so San Francisco was the first county to adopt it, primarily because in San Francisco there's not a lot of vacant land. So it was kind of an easy sell. There's some other counties, I think LA and Alameda, which is where Oakland is located and where we're located. There's a lot more controversy over whether or not this is actually going to be adopted. One interesting note about that legislation, and something that's just been swirling around in my head and our head as an organization, was maybe a potential unintended consequence where agriculture will be allowed for 5 years, but then what happens after that? And how does that relate to the fluctuating housing market and land values in urban areas, and whether it's a short-term or a long-term benefit for urban ag generally?
So I think I wanted to recognize you next.
Thank you. Jeff LaJava with the Land Use Law Center at Case Law School. We've been doing a lot of work on urban agriculture throughout the Hudson Valley. And so thank you to all the panelists for your excellent presentations. One of the interesting kind of nuances that you deal with in states like New York and New Jersey, which are strong home rule states, is how do you, again, balance these competing interests between the need to promote urban agriculture, but the recognition that communities want to have a say. And so obviously, I think going back to your experience in Howard County, community engagement and the community planning process is critical. The one thing I wanted to ask the panelists, because I'm not familiar with Right to Farm Act laws in other states, is that, for example, in New Jersey, they establish a threshold for what constitutes a commercial operation. So it allows larger operations where I think if it's 5 acres and $2,500 worth of produce, for example, constitutes a commercial operation. If it's less than 5 acres, you have to produce $50,000 worth of agricultural production. In that case, what it allows is regular commercial operations to act if they're within the agricultural management practices of the state, to be within the protections of the right to farm law. For those agricultural operations that fall below the threshold, then it gives the community the opportunity to address this through local zoning. And then, of course, you have to work on a community-by-community basis. And I was wondering to what extent in the states that you're operating in, that you're trying to find that balance between these important competing interests, promoting urban ag, but recognizing that we want to reduce neighbor conflicts.
That's a great question, and also trying to figure out what are the thresholds of what constitutes these different.
I mean, part of the problem in Michigan is, for example, they've effectively done away with the coming to the nuisance portion of it. And the courts have been, I think, equally wrong-headed in that they assume that commercial, if you sell 1 dozen eggs a year, and that there's some sort of odd. On the other hand, what you're suggesting, New Jersey seems to be flipped on its head. I mean, it's less of a problem if you have a coming to nuisance in place, like it should be. But they're going to be, from a larger operation, more nuisance-like effects. I mean, it seems to me in some ways the local community has more need to be able to have some say as to how the operation goes. The bigger and the more commercial it is, plus just the political reality, and like I said, my problem with Michigan is basically all of these decisions were made based upon pressure from very large CAFO operators, very large, commercial pesticide producers, all this sort of thing. Precisely the area where you really need at least citywide impact, not otherwise.
Yeah.
Just one brief point. In New Jersey, the interesting thing is if you fall within a commercial operation, basically it's presumed that you're acting, within the confines of the ag management practices, but then it gives the opportunity for neighbors to then go through an ag mediation process where there are those neighboring conflicts before it even gets into the court. So again, continuing to work that balance. And
the Michigan Act also provides for you can go through, or your only option, it doesn't ever go to the courts, is to go through the ag department process.
As I say, Maryland's does the same thing too. You have to go through mediation before you can go to court.
Jason, I want to recognize you. You had your hand up.
I have two sort of interrelated questions for Jackie. And although the
other
questions are
panels.
specifically about Detroit, I think they relate to Baltimore because there are some similar conditions. The first question is, what's the importance of attaching conditions to land giveaways by the local government? Because when you're talking about Hants, I can see him getting a large consolidated piece of land and promising that it will be ag-based for 20 years. But then at the end of 20 years, it becomes the developer's bonanza, where all the benefit goes to the developer and all the value is sucked out of the local community. And the related part is when you have that kind of consolidation, and again, it relates to Baltimore because we have a for-profit organization called Big City, which I assume is trying to consolidate various operations. Don't you have to worry about market power then diminishing competition? And because when you have a big operator and you have small operators trying to compete in that market, and a big part of this is stimulating the local economy and giving jobs. When you have that consolidation, you stifle competition, but you also probably have them paying lower wages than smaller concerns like.
Unfortunately, nobody pays very good wages at this point, but I'm not sure I can summarize the question because it's so interesting and complex. I think you're stating very well the concern with Hants. I mean, there's some additional concerns, is that, at least that I have, as a Fortune magazine profile about 4 years ago pointed out that he paid $1 million fine to the SEC, which suggests some concerns about good faith. But what seems to have, and again, Detroit, we came through a fairly corrupt period. Things are much better that way, even apart from the emergency manager. But my understanding is that insofar as the land has been granted, there are no, being an old property professor, I would put on a condition subsequent on the land with some sort of negotiation, because I think it's very clear that it's a holding, he's thinking long-term, and the focus of the debate in the community has been simply recognizing that this is a long-term investment strategy. Is it worth it? And that's where a lot of the good-thinking folks disagree very strongly. I'm very troubled by it because just the nature of the Detroit on the river, all the infrastructure in place, it's unclear how long the before full development back. You can still buy a house that can be fixed for $5,000 to $10,000 in the city. So, and one of our sort of bigger concerns, at least Hans is a local guy, as opposed to the Chinese that are coming in and buying big tracts of land that they're probably just planning on holding. I mean, there are those sorts of problems. I think it's a real issue, and in a sense, your concern about economic and monopoly power is what's going on. And this is what the public meeting specifically about the sale to Hans, across the board, the community was concerned with, is because he's a big guy. And he was able to push those sales that are, there's a ordinance in Detroit that for $300 you can buy an adjoining lot. But to do it takes 3 to 4 years, or at least has. His, money greases the skids. And a lot of the anger was not even about letting him do it, but about why is he getting special consideration on this when I want the lot next door so I can grow my strawberries and whatever. So I think it's a real problem. I think it's a hard solution, and even though I'm very excited about what's happening in the city, there's a sort of dynamism. I've lived there now since 1970, so I've sort of watched things come in. I'm crazy for the city. But I think there is a real concern about how this is going to operate and what do we want long term. There is a plan called Detroit Futures that has laid out what should happen. The problem is they're wonderful folks, they're planners, and they produced a beautiful book about this thick that is almost incomprehensible, which I think is one of the problems with doing a coherent plan. And I apologize for rambling on.
Oh, that's okay. We have just a few minutes left, and I want to try to, give other people an opportunity. I thought there was a hand here.
I think it was me.
It was you, yes, and then I'll
I
come
was
to you.
going to ask about home rule.
Okay.
Ask.
Okay, great, all right.
How much of the Victory Gardens, 1940s for urban
Oh, yeah,
areas,
the Victory
is
Gardens.
still viable and still being used to promote urban farming, agriculture, gardening?
To my, you want probably to know
Anybody else want to respond?
I think after my
You're
understanding
too
is
young
after
to
the
know
war-
about Victory Gardens, no.
Well, actually, all of us are.
Not me.
But I think the term has continued in myth, but I don't think there's about as much connection with that with what's happening now as there was between the Pingree potato patches and the Victory Gardens. That they were sort of responses to immediate problems and then sort of dissipated. But I could absolutely be wrong.
I
Okay,
just
go
going to make a
ahead.
quick
Go
comment
ahead.
about
Yeah,
that.
sure.
Just was recently in Boston and walked through the commons where the old Victory Garden was, and that's still there.
Yeah.
And San Francisco has a long tradition of Victory Gardens as well. Actually, the community garden that I'm a part of was an old Victory Garden, so it's been in existence for 70, 80 years now.
So do those codes, how did they make that viable? Or was it codified, or, how did it come about allowing people to do that?
That's a good question. Our community garden actually is sort of just sliding by. We're
Under
on
the radar.
yeah,
Under the
ra-
corn.
Under the radar.
Yes.
Planted corn as a fence.
I just wanted to add from the Philadelphia's perspective, an answer to that.
Okay.
We have a lot of gardens that come out of the gardening movement of the 70s, lots
Yes.
of gardens that are 30 to 40 years old. I also have I garden in the Eastwick and Southwest Philly on a 10-acre, almost 10-acre garden that's comes out of the urban renewal era, so 60s. And my first client gardens on land that was vacant in the 30s and 40s. And so that space has been continually maintained as community space, and they actually finally got, so the question about the viability is that most of them are landed secure. Central Club for Boys and Girls, which has been there since the 30s and 40s, actually finally got possession through adverse possession. So if, we've talked about that in property class, it is actually a viable thing, even though in Pennsylvania the statutory period is 21 years. Some of these spaces are really old, but really landed secure.
Is anyone here from south of Maryland? Because it would be interesting to get some perspectives on sort of how do these issues and laws look in the South, where where typically and traditionally and historically, gardens have been, you know, more a part of people's lives. Not to say that they haven't been in the Midwest, but I think some of the more urban areas has not been at the table quite as long. So I saw a couple hands, if you would respond.
Sure. I'm from Durham, North Carolina, and just about a year and a half ago, after about a year's effort, we passed a new urban ag ordinance or amendment to the planning ordinance. It went a long ways to addressing some issues, but it left some others on the table. A couple of the key things that it did allow was we can actually farm or garden in the city and sell our produce, which was illegal up until that point. So now I'm able to get my farm started. I've got a 6-acre farm I'm just building up right now.
So are you in the city of Durham or are you in the
city
county?
limits,
Okay.
In the city limits, yeah. They also allowed us to do a little bit more with composting, which was pretty much blanketly illegal unless it was just, say, produce from your house or your garden and you wanted to turn it back into compost. Now we can actually bring outside material in as long as it's you know, just vegetable material, but we can't sell it. But that's my next challenge is to get that working. But at least we can build up our own soil with outside material from restaurants or breweries or whatnot. So we did make some progress with that in the last year.
Great, appreciate that. Did you want to comment as well?
You know, I'm also in Durham, North Carolina. Kevin Blood told me about the event today. My project's actually out in the county, in the rural tier, where down south you can farm. But,
That's right.
You know, I don't know anything about in town, as Kevin said.
Yeah, great, thank you. Jackie?
I'm saying, I met at a conference that Paula put on, folks from New Orleans, and one of the things, I mean, I'm not an expert, but one of the interesting things we found out that the closest parallel in terms of what's happening and the role people are trying to do with urban ag is New Orleans and Detroit.
Interesting, yeah.
I could talk a little bit more about that. It seems like New Orleans is pretty permissive in terms of what people can actually do and that they can sell, but it has a really strong, a very interesting property regime and a very strong private property regime and a codified definition of blight. That is
Of what?
a codified definition of blight.
Blight, gotcha, blight.
That may actually include growing food on a lot. Because there's a real push for, you know, highest and best use housing development. And if it's not, you know, if you're not maintaining your property in a certain way, imagine all the historic preservationists in New Orleans, right? If you're not maintaining that, there's a risk that you could lose your property. So there's some interesting stuff going on. It's very different. I work in New York City, and New Orleans is very different. Actually, how strict it is around property. New York has pretty strong common law protections. Louisiana is different. Doesn't have that.
So are you saying New Orleans has very strong property laws,
They're
or
very-
the opposite?
They're very strong private property laws, but at the same time, the city has the right to enforce a blight law. So on the other hand, it's actually might be not what we're used to, but it's kind of about maintaining a certain aesthetic of the city and personal responsibility as opposed to community benefit and this idea of highest and best use. Some of us are familiar with economic rubric for deciding whether someone is doing a good job with their land. So it's
Well, I want to thank all four of our panelists. I think that they brought such interesting and varied information. I think the takeaway is really, you know, that we still don't know why Paul went to law school. We still don't know the answers to all the questions. I think the right questions, however, are being raised. I think this notion of community engagement and trying to determine who the stakeholders should be and to look in unlikely places for some of those stakeholders, I think is an important issue. And also this notion of sustainability. You know, what happens when, you know, after 5 years or 25 years, you know, what next? And so I really want to thank all of you for participating and for your important and significant questions and contributions. And I'd just again like to ask you to give our panelists a round of applause and to engage with them later.